You are a very intelligent witness. I've just proven it. Intelligent witness, by the way, is a term of art in law. Meaning to say, ang witness nakakaintindi. I think, Mrs. Swanson, you are trying to tread on as few toes as possible. You are walking on eggshells. That's why you are very, very strict about the way your answers should be interpreted. If that is the case, I will oblige you. As a former trial judge, I'm struck by the fact that your adversaries have done nothing except to issue denials. Itong si Ms. Swanson, nagsasalita siya at binibigyan niyang petsa, ang pangalan, ang address. Samantalang makalaban niya ngayon, nagalit sa kanya dahil magtestigo siya laban sa kanila. Wala nang ginawa kundi deny, deny, deny. Ngayon, ano bang sabi ng batas tungkol sa denial? As a law student and as a lawyer in the courtroom, I implemented the rule that a positive assertion, like your affidavit, is given more weight in law than a negative assertion, like the denial of your adversaries. For your education, please allow me to quote certain recent decisions of the Supreme Court para matapos na itong debate sa dyaryo, na kung pakinggan mo lang, alam na alam nilang batas. Hindi ganon yun eh. Ito, ang sabi ng Korte Suprema, we have laws, but these laws are interpreted by the Supreme Court. The court tells us what it means. Ngayon kung merong nagsasabing positive, nangyari yon. Merong nagsasabing hindi nangyari yon. Ang sabi ng ating Korte Suprema, paniwalaan natin ang nagsasabi ng positive, hindi ng negative. Kasi kadali lang magsabing hindi totoo yan. Said the court, denial is an inherently weak defense and has always been viewed upon with disfavor by the courts due to the ease with which it can be concocted, as in this case. Verily, mere denial, unsubstantiated by clear and convincing evidence, is negative self-serving evidence which cannot be given greater evidentiary weight than the testimony of the complaining witness who testified on affirmative matters. People versus Monte Calvo, decided in 2013, only a few months ago. Next case, quote, both denial and alibi are inherently weak defenses which cannot prevail over the positive and credible testimonies of the prosecution witnesses that appellants committed the crime. Unless substantiated by clear and convincing proof, such defense is negative, self-serving, and undeserving of any weight in law. People v. Nelmida, 2012. One more case, because there's an entire line of cases like this. Under the evidentiary rules, a positive assertion is generally entitled to more weight than a plain denial. Career Philippines, 2012. Denial, like, this is my favorite. Denial, like alibi, as an exonerating justification, is inherently weak and if uncorroborated, regresses to blatant impotence. Blatant impotence. Impotent na, blatant pa. Lalo na kung matanda na. Thus, Mr. Witness, I humbly urge you to be as specific and detailed as possible in your replies to me, because such details are badges of truth-telling. If you do so, your adversaries will be revealed as blatantly impotent. Kaya, kung minsan, please excuse the manner in which I will ask you questions since we are old friends. I do not mean to be rude to you. I'm just carried away by my passion for the point that I'm trying to make. Next point. Mrs. Swanson, please forgive me, but I have to educate you first. There are two kinds of evidence in law. One is called direct evidence, the other is called indirect evidence. Direct evidence is sometimes also called eyewitness evidence. That is to say, what the witness saw with their five, or perceived with their five senses, without calling for any presumption or any inference. Indirect evidence is sometimes also called circumstantial evidence. And this kind of evidence is based on inference or presumption. You see, you're always answering, I presume so. That will become indirect or circumstantial. That's why I keep on insisting, will you please say outright? Because it's like this. You are presenting direct evidence. You're an eyewitness. Is there anything wrong with your five senses? Eye, ears, nose?